Hello everyone and welcome to my podcast, Human Rights, How Do They Stack Up? Where we explore different aspects of the legal system and whether they uphold or undermine human rights. With every episode there will be a survey attached in the description so you can feedback whether you liked it, whether there's anything you would suggest to improve, so please do fill that in once you've listened to the episode and enjoy. So, when I began typing up the script for this episode, I'll admit, I didn't know where to begin. Words, especially not mine, didn't seem to be able to capture the horrific consequences of the inequalities that exist within our justice system. George Floyd, Stephen Lawrence, Johnny Leher. Those names hold a wealth of suffering and the harsh reality that our justice system at times still fails to uphold human rights. Those names are one of many testimonies to that truth. What my words can convey are the facts. The Equality Act of 2010 states, "You must not be discriminated because of your race." It's meticulous and absolute in its wording. You cannot really argue with that. Yet the statistics illustrate a different story. The Lamy Review found that BAME men and women represent 25% of prisoners, despite making up only 14% of the UK population. In 2018, over 50% of adults arrested in London were from minority ethnic groups. Within drug offences, BAME defendants were 240% more likely to receive a prison sentence. The anecdotal evidence, however, exposes a brutality that the numbers don't quite achieve. Stephen Lawrence was only 19 when murdered in a racially charged knife attack by a group of white youths in 1993. Johnny Leher died beneath the weight and excessive force of police officers in a hospital as they attempted to restrain him. And in 2020, George Floyd stated 20 times, "I can't breathe," with a police officer's knee against his neck. However, it's important to note that this isn't just an individual issue. Yes, the respective perpetrators are to blame for these unjust and undeserved deaths. But these young men were victims of a wider systematic problem within our justice systems. One example of this can be found in the case of Johnny Leher. The officers responsible for his murder were not charged, so his mother decided to sue for the use of excessive force. Almost immediately, though, she encountered an almost impassable hurdle: the US legal doctrine of qualified immunity. This legal concept dates back to 1967 and comprises of a two-part test. Firstly, the claimant who has brought the case forward must prove the use of excessive force in violation of the Fourth Amendment, which, in theory, should be relatively easy to establish. However, the second part of the test stipulates that the police should have been aware their actions violated the Constitution because court precedent clearly established their conduct as unlawful. And this is where the problem is. If one can allege the smallest of discrepancies within the fact pattern of the case of precedent with the current case, then there is no clearly established precedent. And when I say the smallest, I mean literally the smallest. The distance between the perpetrator and victim, the setting of the crime. If any of these minute details differ between the two cases, then the court can rule there is no clearly established precedent. So, the officers are therefore protected by qualified immunity and the case is dismissed. Yet, the US Supreme Court has justified the doctrine. The first reason is that qualified immunity provides officers the knowledge of legal protection and hence enables them to perform their job properly. This, however, has been disproven by psychological studies. The knowledge of legal protection makes no impact whatsoever on the attitude and actions of police officers. Which makes sense. A police officer doesn't exactly draw a weapon and think, "Oh, that's okay. Qualified immunity will protect me from any liability." The second reason provided by the US Supreme Court is that qualified immunity protects police officers from bankruptcy due to the financial burden of civil lawsuits. But it's important to note that the actual costs of a civil case are unlikely to be directly attributed to the individual officer. Instead, they're actually shouldered by police insurance companies or police unions. So this doctrine, based upon the aforementioned justifications, refuses accountability, liability, or damages to the victims of police brutality. Just one example of how the law itself is not fit for purpose. However, I would like to highlight that the government and institutions that have attempted to tackle these disparities have encountered relative success. One of the first examples I personally learnt about was the Macpherson report, which was incited by the murder of Stephen Lawrence. This report was chaired by Sir William Macpherson and would, and I quote, identify the lessons to be learned for the investigation and prosecution of racially motivated crimes. The conclusion was that the murder investigation into Lawrence's death had been, and I quote, marred by a combination of professional incompetence, institutional racism, and a failure of leadership. This resulted in 70 recommendations to ensure zero tolerance for racism, reaching even to the civil service, judiciary, and NHS. Essentially, this report was designed to expose institutional flaws and hence incite change in accountability and race relations. However, I do think it is just as vital to evaluate the effect of such reports. Yes, the issue has been identified, but then to what extent has change actually taken place? By the end of the 2 years following the report's release, 67 of the 70 recommendations resulted in specific changes in practice, such as focused targets for the recruitment, retention, and promotion of Black and Asian officers, as well as the establishment of the Independent Police Complaints Commission. Personally, I think that's an impressive figure. It indicates a willingness within institutions to reflect on and tackle institutional racism. Yet, if we look at present-day statistics, we can also see that despite significant improvements, there are still discrepancies. The Lammy Review noted the shocking lack of diversity within the judicial system, whereby 11% of 16,000 magistrates, whom, you should note, tackle the majority of court cases, are from BAME backgrounds. The proportion of 3,000 court judges is even smaller at 7%. One quote from the review particularly stuck with me. At virtually every recruitment round, BAME applicants have been recommended for positions at lower rates than they applied. So, what can we take from this? There are applications for these positions, but they are not being accepted. Obviously, this requires further investigation before coming to a conclusion about the causation of this discrepancy. But it does indicate a fundamental disparity within the system in how our population is represented. As a side note, I would thoroughly recommend reading this review. It's accessible and extremely revealing of the state of the justice system, although it was published in 2017. Therefore, it's not completely up to date. However, a more up-to-date piece of evidence is the FT, which has recently published an article titled Race Relations, the Police Battle to Regain Trust Among Black Britons. All these links will be published in the description so you can access them whenever you wish to. The article reported that in the first national lockdown, there was a rise in reported incidents, with black people 3.7 times more likely to be stopped and searched than white people. And this was in November 2020. One explanation for this disproportion is the dynamics of the lockdown itself. Black people are overrepresented in sectors such as healthcare and transport, and therefore are more likely to be out and about. I think this is completely plausible, but it is also a sad reflection when considering the significant rises in the number of stops and searches from a year earlier. What is even more concerning, though, is the attitude of the UK's black population towards the justice system. In London, which homes half of the UK's black population, there was a 15% fall in those who are confident in police fairness, whereas Londoners in general had a fall of only 3%. This can be attributed to high-profile incidents such as Bianca Williams being handcuffed by police in July. However, what the article didn't seem to mention was a growing sense of awareness and injustice, from which we have seen a resilience forming. People are on the streets calling for equality and fairness from the justice system, as they are entitled to by right. Yet there is still a lag between the experiences of minorities and the extent to which social action is taken, adopted, and then nurtured by our justice system. Instagram stories and furious tweets can only do so much. Genuine change needs to take place, and we can aid in it, because end of the day, we shape the justice system. It's a reflection of our principal norms and values. I hope this episode has enlightened you as to some of the struggles our justice system faces in terms of race, and potentially even inspired you to do further research. Please do have a look at the links that I have put in the description below. They're incredibly insightful and will truly help you gain a better understanding of the disparities within our justice system, and even how we can help tackle them and how we can help improve our justice system.